come to the Senate, what is the Senate required to fashion in such an impeachment proceedings? One, it's that these proceedings must be open to the public. The motion must be made available to the public, and if they want to attend, depending on logistical constraints, they should be allowed to attend. My lords, my lady, you will see from the Hansard that this was done. These proceedings were public. They were members of the public were also allowed to attend. It was televised. It was on the website. There's a YouTube page on which Senate proceedings are aired. And the voting, the decision, the discussions that the senators undertook, the submissions by council and by the National Assembly, they were all open and available to the public, including the request for adjournment and including the final vote where the House decided to proceed. All that was public. None of it was done in secret, and therefore the allegation that the Senate did not do public participation is not correct. Then the Court of Appeal proceeds to say public participation does not dictate that everyone must give their views on the issue at hand. This goes back to Mr. Masharia's submission on 0.014%. The numbers do not matter. What matters is what was done. Did it reach every single person in this country? Were they aware of what was happening? And I will say that from the efforts that the Senate made to make sure that everyone, and it's televised and it's on the website, that is public participation in the context of an impeachment of a Senate sitting as a trial court. That is public participation. And finally, and most importantly, the right of public participation is not meant to usurp the technical or democratic role of the office holders, but to cross-fertilize and enrich their views with the views of those who will be most affected. Documents from the National Assembly and from the petitioners, and what was required of them is to make a decision based on the material before them, the grounds before them, the evidence before them, and make a finding whether it had been substantiated. So it matters not that there is a section of the country that did not agree with the process. What matters was what was before the Senate, and the senators were required to make a decision based on the evidence. And they did make a decision and found that there were grounds that have been substantiated. So, my Lord, we are saying that what the petitioners are arguing, that there is one brush for both houses of parliament, in this case is not correct. And on the question of case-by-case basis, we are saying that when the Senate is sitting as a trial court, the public participation looks different from when the Senate is undertaking its legislative mandate. And because at all times the proceedings, the debate, the documents were available to the public, there was public participation. And there was also a submission from Mr. Masharia again, that the Fair Administrative Action Act requires public participation, and my colleague has submitted that this is a constitutional function. This is a House of Parliament sitting to discharge its constitutional function of oversight, and there are proper parameters that apply for public participation. Then, my Lord, I'll move to the next issue, that there was an allegation from the petitioners that there was new evidence and witnesses allowed to submit to the Senate, which made the process unfair to the petitioners. My lords, my lady, you will see from the Hansard, the Speaker did give a ruling on this matter, and he referred to Rule 7 and 8 of the Rules of Procedure. The Speaker finds that Rule 7 and 8 permitted the Senate to receive witness statements, list of witnesses, and any other evidence. The Speaker then proceeds to say, what is not allowed is to introduce new allegations or introduce evidence that is extraneous to the allegations. And based on what had been presented, the Speaker ruled that the documents were permitted under the Rules of Procedure. They were provided to the petitioners. They had a chance to respond. And so that issue that they were unable to proceed with their case or it affected their fair hearing is dispelled by that communication by the chair. It's in the Hansard, which we have provided to the court. My Lord, the final issue which I wish to highlight on is the Speaker of the Senate has been accused of bias because he was a member of a political party or a coalition. If you look at Article 106 of the Constitution, for a Speaker to qualify to be appointed as Speaker, you must qualify to be appointed as a Member of Parliament under Article 99(1)(c). What this means is either you are nominated by a political party, or if you are an independent candidate, you are supported by at least 2,000 registered voters in the county. So definitely, the person who becomes Speaker is someone in the political realm. However, when they do become Speaker, under Article 107, their role is to preside over the House, and under Article 122, the Speaker has no vote. The Speaker, even on the adjournment, he had no vote. He had to put it to the House and leave it at that. So when the petitioners allege bias just by virtue of the fact that the Speaker was active in politics, there is no evidence. There's nothing that has been produced to show that the Speaker did or did not do anything that was required of his role. And my Lord, we ask you to throw out that ground of the petitioner's submissions. Finally, my Lord, if you look at the Hansard, there was equal time allocated to both parties, both the National Assembly and the petitioner or the respondent in the Senate. They were allocated equal time. So they have alleged that there was no equality of arms. That's not correct. The Hansard will bear us witness that they were given the same time as the National Assembly, and it was up to them to organize their case and how they would like to proceed. Therefore, my Lord, we ask that you dismiss the petition. Yeah. Thank you. Yes. Yes.
Senate is not obligated to do public participation.
Yes.
From the submissions, I gather that you are saying,
yes,
in fact, there was public participation in the Senate. Can you please clarify the position of the team?
Yes, my Lord, the position is we are bound, the Senate is bound by Article 10 and Article 118 and complied with that requirement. What we are saying is the obligation is not the same as the obligation on the National Assembly, but there is a requirement and there was compliance. I don't know if I've answered.
So the submissions by a part of the team that
yes,
the Senate is not obligated at all, it's
not erroneous. I'm qualifying that the Article 10 and 118 require that we facilitate the public.
So from that submission.
I'm qualifying, my Lord, that that obligation is conducted in that manner. Yes, yes, thank you. That is the correct position. Yes, thank you.
My lady, we had prayed for 2 hours. We created
can't come before.
No, he made us. I just wanted to note that we are seeking his response.
Thank you very much, my lord.
Mr. Tomoto, I think by yesterday you are notified submissions.
My lord, we already filed our submissions a while back. Our submissions are dated the 24th of April 2026. They are already.
Do you feel it prejudice if Dr. Kankul proceeds?
There will be no prejudice in my view. In fact, I suspect that we make my work easier by 98%.
All right. Thank you. Proceed.
Thank you very much, my lord. My name is Modomidi Nkolu. I appear for the second interested party, that is His Excellency, Professor Kithure Kindiki. I am joined by Mr. Moses Kipkogei, Kennedy Meli, Steve Ogola, Boniface Mwereru, and Kenson Mutevia. In that representation, for today I'll be sharing the time with Mr. Kenson Mutevia. For the record, my lord, we filed the following documents, which we urge the court, when you retreat, to peruse. One of them is the replying affidavit sworn by His Excellency Professor Kithure Kindiki on the 20th of February, the year 2025. We have, in addition to that, filed submissions dated the first day of October, the year 2025. Number 3, we have filed a list and bundle of authorities, also dated the first day of October, the year 2025. And lastly, we filed an affidavit dated the 8th day of May, the year 2026, in response to the issues raised in the affidavit filed by Dr. Gachagua. My lord, I have reflected quite deeply on the matter before the court for the last 2 years, and I have not been sure, perhaps because age is catching up with me, whether the petitioners actually believe in the allegations they have brought to you. But in the course of that reflection, my lord, and in the course of practice of the law in cases like the one before you, it has occurred to me that it is quite easy in a dispute like the one you're now hearing to lose sight of the real issue. You know, lawyers come in their various grandeur and sophistication, and they say 1,000,001 things. And in that forest of very many things, allegations and counter-allegations, my experience is that it is easy to lose sight of the real crux of the matter. And to me, the real issue, my lord, may be formulated in 3 ways. One of them is whether the courts, not just this court, but any court anywhere in the world, whether courts should quash the impeachment of a deputy president that has been found guilty by Parliament of inflammatory ethnic incitement that threatens national unity, especially in a polarized, multi-ethnic country like Kenya. We know, my lord, what ethnic incitement did in Yugoslavia. We know what it did in Rwanda and Burundi and many other places. And for me, the question is whether a judge, a court of law, should reverse an impeachment conducted on such a ground in a country such as the one we live in a country with experiences such as those we had in 1992 in Molo, such as those we had in the year 2007 that we call the post-election violence. Should courts really do that, my lord? even as lawyers try to draw your mind in 1,000 directions. Number two, my Lord, should courts quash the impeachment of a deputy president? We are not talking about a street sweeper. We are not talking about a junior clerk, but a deputy president of the Republic that has been found guilty by Parliament of threats to judicial independence. A deputy president that goes to the press vilifying and accusing judges of this very court of things that he shouldn't be saying, and does it count for anything, my Lord? When I was reflecting on this, my Lord, it reminded me of my many days in high school when we used to be taught a proverb in Kiswahili that says, usitusi wahenga na uzazi ungalipo. Does this petitioner even have the reflection perhaps to apologize to the courts for having been found guilty of insulting them? And now that he finds himself in a position perhaps he wouldn't want to be, he now comes back to the same courts, raising heavy weather about 1,001 grievances. And lastly, my Lord, should courts, and I don't mean just the courts of Kenya, it is the courts of any country, should courts quash the impeachment of a deputy president, not a clerk, not a messenger, the deputy president who has been found guilty by Parliament of utterances and press conferences that strike at the very heart of the need to maintain national security at a time the nation is in an existential crisis, such as the one we had in the year 2024 with the so-called Gen Z uprising or Gen Z riots and whatnot and whatnot. At the end of the day, my Lord, that is really the broad question before you. And my Lord, when I was thinking of this matter also, I was quite amazed to hear that the petition is being likened through a false analogy to Jesus Christ, to Socrates, to Thomas More, and other great men and women in history. And for me, my Lord, I was left wondering, perhaps the correct analogy should, and I'll show you shortly, should have been that with Barabbas, the mighty criminal who the masses chose, or perhaps the two unrepentant, or rather the unrepentant criminal who was crucified together with Jesus Christ. But while on this, my Lord, again, because sometimes we love analogies and they mislead, did Jesus Christ traverse Galilee and the southern part, Judea, preaching ethnic exclusion, preaching ethnic hatred and incitement? Did Jesus Christ traverse Judea and wherever, trying to vilify judges in public utterances instead of following the mechanisms? Was Jesus Christ really guilty of the sort of things? Because you were told, I don't want to address you on whether it is blasphemous to even liken a man with Jesus Christ. I'm not a very religious man, so I'll leave that to the religious people. But the overarching legal question, my Lord, is whether, as a court of law, because a lot of emotions have been stirred in this case, we are in a court of law, my Lord. This is not a sympathy parade. It is not a political forum. It is not a political platform. And to the extent that we are before a court of law, we must confine our inquiry to the four corners of the law. If the law supports the petitioner, then he is entitled to whatever the law gives him. But if the law doesn't agree with him, he cannot ask you to stretch it. The law is not an accordion that you can keep stretching and expanding and contracting. The law is cast in advance so that we have prior notice, so that we can calibrate our behavior to accord with it. And the overarching question, my Lord, is whether this impeachment complied with Article 145 as it is, not Article 145 as we may wish it were. The overarching issue is whether this impeachment complied with the standing orders as they were, because Parliament was working with the Constitution as it is. Parliament was working with the standing orders as they are, and it cannot be permissible to come after the event and tell you many of the things you have been told. My Lord, without revisiting the issues that my pupil master, Professor Gideon Muigai, told you, sometimes I tend to have a fairly strong tongue, and that stands in the way. But there is a point we are trying to make, and which I think Professor Muigai was trying to make, with all the humility, my Lord, that we can master. And that point is that, you know, the power of the courts is a limited power. Just like the power of parliament is limited, just like the power of the executive is limited, there is a temptation and a general assumption among public law lawyers, especially lawyers who practice in the constitutional division and the judicial review division, because the courts usually have the last say on the legality of something, there is a temptation, my Lord, to assume that the judicial power itself is not limited. And that cannot be true, my Lord. That is why what is supreme is our constitution. It is not parliament that is supreme. It is not the president or the executive. It is not even the judiciary that is supreme. It is our constitution. And if we accept the general premise, my Lord, without appearing or sounding haughty or arrogant, if we accept the broad proposition that judicial power is limited, it must follow the things courts cannot do. And one of the things the court cannot do is those questions I began with, whether courts can quash and reverse an impeachment of a deputy president of the republic done on the grounds, on the facts before you. My Lord, the idea that judicial power is limited is not just my submission. It is something we were all taught in Law School 101 under the doctrine of separation of powers. And because Alexander Hamilton was quoted here, he wrote Federalist, paper number 78. And in that paper, my Lord, he says the judiciary only has the power of judgment. The judiciary only has an interpretive power. It cannot make law. It cannot stretch. It cannot expand our constitution. It cannot expand any law. Of course, there are inherent limits on that. And my Lord, if you need judicial authority going beyond, the philosophies of Alexander Hamilton when they were founding the American state, you can go to Chief Justice Roberts of the United States Supreme Court in a very recent decision called Obergefell and Hodges. And in that decision, when you read rights reports at page 160, and I'm referring in particular to the judgment of the Chief Justice of the United States, Chief Justice Roberts, pages 181 and 182. And when you read it, my Lord, he complains that the Supreme Court, in making that decision, what the majority were doing was not an exercise of judicial power. He says, he accuses the Supreme Court majority of varying an institution that had been fixed by all human civilization, going to the Khoisan, going to the Aztecs, going to the ancient Chinese, going to the ancient Egyptians. And what I love about it, my Lord, he says, the majority's decision is an act of will, not an act of legal judgment. And he concludes by asking, just who do we think we are? This is a Chief Justice, just 2-3 years ago, asking his colleagues in one of the most respected Supreme Courts in the world, just who do we think we are as judges, so that we would have the audacity to do some things. And that is the context in which we are saying, my Lord, that judicial power, just like executive power, just like legislative power, is limited, and there are things judicial power cannot do, even when it is stretched to the outer contours of its margins. And my Lord, why we say this is that the misconduct established against the first petitioner, the misconduct for which he was impeached, is serious misconduct. But more importantly, my Lord, it is a misconduct of a type that can pose existential threats to our republic. It can bring existential threats to our governance architecture, especially when it is committed by the second highest officer of the state. It is notable, my Lord, this power of impeachment, because again you were told, we should invoke it as the last bullet, as a means of last resort, and many other short stories. The structure of our Constitution is that this power of impeachment is actually only available against the very highest people. And there is a good historical, philosophical, and legal reason, my Lord. It is because it would erode the dignity of our governance architecture to have a deputy president in handcuffs recording statements before a police station here and being arraigned in court and whatnot. That is the philosophy historically, why it was agreed in England way back in the 1300s, in Americas when they were founding their republics, that senior state officers found guilty of high crimes and misdemeanors, found guilty of gross misconduct that is incompatible with the inherent dignity of the office they hold, then Parliament, not the courts, Parliament was given the power to remove such officers as an exercise of delegated sovereignty or as an exercise of the constituent power of the people. My Lord, Article 145 is designed to protect the Republic. It is not designed to protect individuals. It is not an article, therefore, you can invoke to say, my right this, my right this. Of course, there is a procedure laid out in that article, and if that procedure is not followed, it is our case that it was scrupulously followed. The point, my Lord, is that Article 145 is public-centric, it is not individual-centric. And if that is the case, it must follow that the impeachment power in that article, my Lord, is a power to preserve the constitutional order, to maintain the integrity of the governance system that the people of Kenya on 27th August of the year 2010 voted for. My Lord, when we say that judicial power is limited, it is not to say you have no power. Of course, we cannot seriously claim you are entirely powerless, because it will mean then we are wasting time here. No, that's not our point. What we are saying, my Lord, is that your power is supervisory rather than appellate. And that has been confirmed by none other than your brother Mongo J, who I think my colleagues on the other side are trying to distort his views on these matters. In that bench, called Martin Nyaga Wambora and others versus County Government of Embu and others. This is the High Court decision delivered in 2015, and in that bench, Mongo J was sitting with Koril J as he then was, and with Odunga J as he then was. And my Lord, they say, these are not their words, they say, a court reviewing the procedure of a legislature is not a super legislature sitting on appeal on the wisdom, correctness, or desirability of the option of the impugned decision-making organ. It has neither the mandate nor the institutional equipment for that purpose in our constitutional design. Moreover, the process cannot be wrong simply because another institution, for example, the courts, would have conducted it differently. It must be accepted that the institutional environment controls the manner in which an organ disposes the issues before it. These are not my words, my Lord. It is the judgment of this honorable court, a three-bench like this one, sitting with your colleagues, some of them whose views now there is an attempt to distort them. But my Lord, what is important about this decision is that it was pushed all the way to the Supreme Court. Again, and when you read at the Supreme Court, the citation of this dispute is Karaoke Mate and others. And my Lord, there is a detail about the Supreme Court decision in that matter that I think both sides, and in my experience, lawyers don't even realize. It is the only decision, my Lord, I've seen where the Supreme Court of the Republic of Kenya has upheld the violation of a high court order and that written in black and white. that Parliament was entitled to disregard this court order because the courts had overreached themselves by trying to exercise a power beyond supervision. They had assumed an appellate power. This principle has also been upheld in the Sonko case, which I need not revisit given the inimitable submissions by my pupil master, Professor Gidu Muigai. My Lord, what is the dispute before you? There is a plethora of grievances. You know, this didn't happen, this happened the wrong way. The key grievances, my Lord, are just four. It is that there was a denial of fair hearing. I'll be coming to this shortly. And as I come to it, I'll be telling you that grievance is mischaracterized. It is a case of what we used to call in Law School 101, distortion and misrepresentation. What was actually not availed to the first petitioner is an opportunity cross-examined. The right that exists is the right to cross-examine on adversary evidence. So the petitioner has actually turned the right on its end. We have a perfect case here of the villain taking moral high ground and telling anyone who cares to listen from all the mountaintops how he was mistreated, how people were unfair to him. He can make whatever lamentations you want to make, my Lord. The undeniable fact is we can go bullet by bullet from paragraph A to paragraph Q of Article 50, sub-Article 2, and he will not be able to show you the specific element that was denied of him. And the reason he cannot do that is because actually the grievance is based on an inverted logic where it is him who has denied his adversary the chance to test his evidence, and the person who has denied the adversary the opportunity of cross-examination cannot turn around and pretend that he was the victim. In fact, the victim was the National Assembly. So, my Lord, you have a case here which is a mischaracterization, and that's why I've told you I've struggled in the last 2 years to understand why are we before you, and why have we ruffled all these waters and made heavy weather of these 1,000,001 things. My Lord, the common law and our legal system, it is the petitioner who should have been imposed a sanction. What we normally do in normal litigation practice is if a party gives evidence, the decision maker is entitled to many things, and my friend Kenson will address you on them shortly about the South African decision. They call it EFF3, we call it Falafala, because Falafala was a place, I think, where whatever happened, happened. But the point I want you to note, my Lord, is that the text of Section 89 of the South African Constitution is fundamentally different. It is not pari materia to Article 145 of our Constitution. If I may illustrate some of the differences, the South African Constitution doesn't prescribe any procedure unlike our Article 145. It leaves all questions of procedure entirely to the National Assembly. The South African Constitution does not prescribe timelines like those prescribed in our Article 145. The standing orders of the National Assembly of South Africa do not provide for the preliminary inquiry committee of the type that was in issue in the South African case. And the point, my Lord, we could go on and on. The removal process in South Africa is fundamentally different from the one in Kenya. Even the legal system is completely different. Although the head of state in South Africa is a president, is styled president, theirs is actually a parliamentary system. Ours is a presidential system. As my colleague Kenson takes the podium, my Lord, I hope I have shown you that this is not the type of case which, even if you woke up in your best mood, you would uphold. Thank you.
Good afternoon, my lords. We had asked for 2 hours. Dr. Modomi has spent 1.5 hours, so I'll be taking the 30 minutes. I can take 20 minutes, my lord. Yes. Okay. You can even go to the website. Because now my focus is to focus on the